Hello, my name is Elizabeth Chilcoat, and I'm here with Amy Knapp, my colleague in the Labor and Employment Department. We are excited to be speaking with you today about leaves of absence under the FMLA, ADA, and USERRA. Before we get started, a couple of housekeeping matters. To the right of the stream, you should be able to see a Q&A box. We would ask that you submit your questions to us through the Q&A box rather than through the chat function, just because I'm not confident in my ability to keep up with questions coming in through the chat. At the end of our talk, we'll do our best to answer your questions. And if we run out of time because you have so many good questions, Amy and I will follow up with you after to make sure we get your questions answered. So with that said, let's dive right in. Our presentation today is going to be divided into 3 segments. The first segment, we're going to talk with you a little bit about the applicable laws that you should be considering when an employee requests a leave of absence. The second thing we're going to talk about then are some scenarios. What we're trying to do is present you with the sort of complex health-related scenarios where there's a leave of absence requested that we often get called in to advise clients on, so that you can kind of see how we follow, how our analysis works, what our thought process is. And then finally, we want to speak with you about some developments in USERRA and some coming developments that will apply in the future under various laws for health-related leaves. So with that, let's dive right in, and we'll speak first with you about the Healthy Families and Workplaces Act. I'm going to take Colorado's new paid sick time law, and then Amy's going to speak with you a little bit about Arizona's, because the majority of the attendees today are from those 2 states. But please remember that if you have employees in other states, or if you're located in another state, your state may have its own paid sick leave law, which you'll need to take into account when you're making decisions about how to respond to an employee's request for a health-related leave of absence. The Healthy Families and Workplaces Act was passed just last year in the state of Colorado, and it has kind of an interesting phase-in program. So it has 2 kinds of leave that it provides on 2 different phase-in schedules. The first phase-in schedule applies to standard paid sick leave. And that's already in effect for employers with 16 or more employees. Employers that are smaller, those with 1 to 15 employees, are going to have this law come into play January 1st of 2022. The other portion of HFWA was the public health emergency leave, which is abbreviated on our slides as PHE. Public health emergency leave was decided by the Colorado Department of Labor and Employment that it would apply to all companies starting January 1st of this year, and that it was triggered by the current pandemic. So Brooke Khaleesi did a nice job of speaking about HFWA during her talk on the Big 5 in Colorado. I'm going to give a very high-level discussion of it. But to the extent that you need more information about HFWA, I highly recommend that if you didn't attend her program, that you go back and watch the recording once it's posted on our website. The paid sick leave, the standard paid sick leave that we have for companies, is requires employers, covered employers, which right now are just those with 16 and more employees. But remember, come January 1st, will be employers with fewer than 16 employees. It requires employers to accrue 1 hour of paid sick leave for every 30 hours that an employee works. That accrual is capped at 48 hours for a year. In addition, there is a usage cap of 48 hours per year. So in theory, an employee could accrue 48 hours and use 48 hours every year. If an employee doesn't use their full allotment, they can carry forward up to 48 hours to use the following year, but that same usage cap is going to apply. The reasons that employees can use paid sick leave are many of the reasons that you would just intuitively expect employees to use paid sick leave. Because they are sick, because they are injured, because they are seeking medical care of one sort or another, because they have a family member who they need to take to the doctor or who they need to provide care to because the family member is sick or injured. There are also two categories that are a little bit not intuitive. And one of those is employees who are the victims of abuse or harassment or assault, these sort of domestic violence crimes. And the other is if a public health emergency forces the closure of either the employee's work site or of wherever the employee's child goes during the day, whether that's school or daycare or whether it's a nanny arrangement or something. So if the child care arrangements fall through, then the employee can use HFWA leave, the standard paid sick HFWA leave. In addition, HFWA requires employers to accrue public health emergency leave. And theoretically, the way that's accrued is in bulk on the date that public health emergency is declared. Employees are entitled to 2 weeks of public health emergency leave. So you supplement their HFWA bank up to 2 weeks time. So that's capped at 80 hours for a full-time employee, but for part-time employees, it'll be prorated. And again, the reasons an employee can use this sort of leave in a public health emergency are fairly intuitive. They're if the employee must isolate or quarantine. They're if the employee has been exposed, and so either the employer or the government prohibits the employee from coming to work. They're if the employee is showing symptoms and needs to go through treatment or obtain a diagnosis. They are also if the employee is unable to attend work in person because of an unusual susceptibility to the illness. For instance, if they have an underlying condition that makes it more likely that they will become infected or be very severely impacted if they are infected. And in addition, public health emergency leave applies to anybody caring for a child or a family member who has any of those conditions, who is forced to quarantine, is sick and waiting diagnosis, is sick and needs treatment, is unable to go to school or to their care facility because of the public health emergency. Now, I want to talk a little bit about how employees request leave. And throughout our talks about the law, we're going to hit how employees request leave because that's a place where you can drop the ball. You don't recognize that an employee has requested leave. So under HFWA, the standard for requesting leave is very low. All an employee has to do is let you know that they need to take time off because of a HFWA covered reason. They don't have to say, I want to take HFWA leave. They don't have to say, I want to take paid sick leave. They don't have to tell you very much. They don't have to give you written notice. They don't have to give you notice in any particular format, and you cannot require them to give notice in a particular format. You cannot require that they give you notice at a particular time. In theory, the law says that you can require employees to provide you with notice as soon as practicable if the reason for leave is foreseeable. However, even if an employee fails to give you adequate notice under your policy, you cannot reject their request for leave. You must still provide them with leave. Finally, in most cases, you're not going to be able to require documentation. And if you can require documentation, it's extraordinarily limited. For standard paid sick leave, if an employee has gone less than 4 days, you cannot require documentation. If the absence is 4 days or greater, you can require documentation, but the employee is not necessarily required to give you the kind of documentation you're used to. If you're accustomed to saying, bring me a doctor's note if you're taking time off because you're sick, you're not going to be able to do that. You can request a doctor's note, but the employee is not required to provide you with one. If providing you with a doctor's note would result in additional cost or inconvenience to the employee, they can simply write you a note that says, I was sick June 1st through 4th, therefore I didn't come to work. And that is the documentation that you must accept, which is a much, much lower standard than you may be accustomed to. There's a question that I'm going to answer really quickly, which is whether an employee who has public health emergency leave should exhaust the bucket of public health emergency leave before dipping into standard paid sick leave time. That depends on how you accrue the time. If you accrue a separate bank of public health emergency leave, then you must draw from that bank if the reason for the absence is a public health emergency reason before you start drawing from the standard paid sick leave. Some companies simply put the public health emergency leave directly into the sick leave bank, and then there's just one bank, and so you do not need to do that kind of record keeping and housekeeping. Now I'm going to hand it over to Amy, who's going to talk about Arizona's paid leave law.
Thanks, Elizabeth. So Arizona has had a somewhat similar statute as the one that Elizabeth just went through in Colorado since 2017, and it's called the Fair Wages and Healthy Families Act. So under this act, employees in Arizona can earn paid sick leave. And unlike in Colorado, the amount of leave that employees can accrue depends on the size of the employer. So if you're an employer with 15 or more employees, those employees are entitled to accrue 1 hour of earned paid sick leave for every 30 hours worked. But then there is a use and accrual cap of 40 hours per year. And employers with 15 or less employees, employers with less than 15 employees, they have the same accrual rate, but the accrual cap and usage cap is set at 24 hours as opposed to 40. And note that under the Fair Wages and Healthy Families Act, you can front load those hours if you choose to. So if that's administratively more easy, you can front load them at the beginning of the benefit year. And the benefit year is defined by the employer, and it just has to be a consecutive 12-month period. So it doesn't have to be the calendar year if that's less easy for you administratively. So usage is very similar to the standard sick leave that we just went through for Colorado. So from a high level, if it's an employee or an employee's family member, in quotes, I'm going to talk more about what that means because it's very expansive under this law. If they have a health condition, including, for diagnosis or preventative care, they're entitled to use their earned paid sick leave. And it also includes a public health emergency that closed the employee's place of work or their child's school. Also includes exposure to a communicable disease. And this is regardless of whether the employee actually has the disease. So for example, with COVID, if the employee knows that they were around someone that has been diagnosed with COVID, they are entitled to use leave under this statute, even though they themselves have not tested positive. And then it also can include leave for domestic or sexual violence, abuse, or stalking. And that can be for an employee or the employee's family member. And the reason for leave for those reasons can be, the employee needs to seek medical attention, they're getting program services or victim services, they need to attend counseling or therapy sessions, they need to relocate due to safety reasons, or they need to add safety precautions at their home, like security cameras and the like, or they need to seek legal services, and that can also include preparing for or participating in civil or criminal proceedings. So family members under this statute are defined very broadly. So it can be a parent, it can be a child, but it's more than just a biological parent or child of the employee or the employee's spouse. It can be their foster parent, stepchild, adoptive parent, legal guardian, a person who stood in loco parentis when the employee or the employee's spouse was a minor child. So it can be broader than you might think. So it's always good to check if it's not someone's specific, biological mom or biological dad. And the same goes for the definition of an employee spouse. So it can be anyone they're legally married to in any state, but it also can be a domestic partner as recognized in any state or political subdivision. So keep that in mind. It can also be a grandparent, a grandchild, or a sibling. And again, sibling is broad: biological, foster, adoptive, or step relationship. And it could be the spouse's sibling in that same scenario. And then finally, there's a catch-all provision that kind of includes anybody. So any other individual related by blood or affinity whose close association with the employee is the equivalent of a family relationship. So if an employee comes to you and they say, my nephew is having these issues and I need to take him to, let's say, some medical care, that could be a qualifying family member under this. So it might be broader than what you're used to, particularly under the Family and Medical Leave Act under federal law. So as Elizabeth said, we're going to be talking about requests for paid sick leave and under each of these statutes. So in Arizona, under this statute, employees are required to make a good faith effort, quote unquote, to provide advance notice of foreseeable leave and to schedule it in such a way that it's not, quote unquote, unduly disruptive of employer operations. So again, that can be pretty broad and it can include a lot of different things. Fortunately, when leave is not foreseeable in Arizona, employers do have a little bit more control, unlike they do in Colorado. So if it's not foreseeable, the employee does have to follow the employer's written policy. It's important that it's written and that it's distributed, and that the policy doesn't discriminate against employees for using earned paid sick leave, and that the employee, and so if all of those factors are met and the employee doesn't have a reasonable justification for failing to follow the written policy, then you can deny or choose not to elect that leave as earned paid sick leave. And so that means that employee might be subject to your standard attendance policy repercussions. So that's something where at least you have a little bit more control. But again, there's a lot of flexible language in the statute. So make sure you're following that and seeking guidance if it seems like it could go one way or the other. Sorry, I went a little too far there. I have one more slide left, and that's to talk to you about documentation. So an employer in Arizona can only request documentation after 3 consecutive days, 3 or more, I should say, consecutive days of absence. And luckily in Arizona, if the reason for the absence is illness, a doctor's note is considered reasonable documentation. And the doctor's note essentially just needs to say that or indicate that the earned paid sick leave is necessary for this employee or the employee's family member, whoever that may be. In case of domestic violence, sexual violence, abuse, or stalking, it's a lot more limited in what, or I shouldn't say limited, it's a lot more specific in what counts as reasonable documentation. So it could be a police report, a protective order, an injunction, a signed statement from a domestic violence, sexual violence program, a signed statement from a witness advocate, signed statement from an attorney, a clergy member, medical professional, or other professional that the person is receiving services related to violence or stalking or the like. And then it can also be the employee's own handwritten, legible, or I shouldn't say handwritten, but it does need to be written statement concerning the employee's status and that they or a family member the victim of the abuse that we've been talking about here. So now I'm going to kick it over to Elizabeth to talk to you all about Family and Medical Leave Act.
So our good friend, the Family and Medical Leave Act, the federal law that applies to companies with 50 or more employees. In order to be an eligible employee under the FMLA, a person must have worked for their current employer for the last 12 months, and they must have performed 1,250 hours of work for the company. In addition, on the date that they request the leave of absence, they must be employed at a work site that is within 75 miles of at least 50 other employees. In terms of health-related leaves, the FMLA provides employees with 12 weeks of unpaid leave for their own serious health condition. Now, remember, the FMLA covers a lot of other things. It provides 12 weeks of leave for things like the birth and adoption of a child, provides 26 weeks to care for an injured service member. But what we're really talking about right now is how HFWA layers in and how Arizona's paid sick leave law layer in with these federal laws. So we're going to focus instead on what a serious health condition is. So serious health conditions are basically what they sound like they are. They're health conditions that are very serious. That's defined as a condition that incapacitates the employee from working for 3 or more days, a health condition that results in hospitalization. It might also be a health condition that requires ongoing treatment or periodic treatment. Things like hepatitis C or cancer might not incapacitate the employee from working all the time, but the employee may need time off from work to go through pretty hefty chemotherapy. In addition, there are some pregnancy-related conditions that can qualify as serious health conditions. However, FMLA also covers leaves related to pregnancy and childbirth. An employee requesting a leave under the FMLA doesn't need to use magic language. They don't need to come in and say, I need FMLA leave. They need to tell you, and by you, that's a pretty broad definition. They need to tell anybody in a managerial or supervisory capacity. So that means your frontline supervisors have to know that they should be listening for this stuff. You need to say that they need time off from work because of a health issue. And that is enough to trigger our obligation to send them a notice of their rights under the FMLA. The employee can then be required to submit a certification of a serious health condition, which is filled out by their healthcare provider. We don't get to choose the healthcare provider. You can't dictate that it be a physician. You can't dictate that it be a physician with a particular kind of specialty. But we, as long as the physician looks like they are, or the healthcare provider looks like they're qualified to opine on what they're opining on, they will give you a really bare bones bit of information. And they'll say this person needs to be off from work this many hours for this long. They will tell you if the person needs a reduced work schedule or if they need intermittent leave. They also have to tell you enough that you can conclude that the employee is incapacitated from working due to a serious health condition. They don't need to give you a diagnosis though. So the information is more than you'll get under HFWA, but less than you would get under the ADA, which Amy's now going to talk about.
Yeah, so the ADA, so first just going to talk generally about the coverage and protections. So a covered employer under the ADA are employers with 15 or more employees. And generally what Title I of the ADA requires is for employers not to discriminate against a qualified individual with a disability. And so that invites the definitions of two terms there. So a disability is, there's 3 prongs under the ADA of what a disability can be. So it could be a physical or mental impairment that substantially limits one or more major life activities. And that's predominantly what we're going to be talking about today, and probably what you're most used to seeing. But it can also be someone who has a history of having such an impairment, or they're regarded as having such an impairment, even if they don't in fact have that impairment. And with respect to the first prong, the ADA Amendments Act in 2008 significantly lessened an employee's burden to show that they have a disability. It broadened that language in a lot of different ways, but suffice it to say, it's fairly easy for an employee to show that they have a disability under this definition. But that being said, still conditions that are of a very short duration and that aren't expected to, or that the employee is expected to fully recover from, typically aren't disabilities under the ADA. We're seeing that we sort of tested recently in terms of COVID, COVID long haulers, they call them, are individuals who have COVID, but they experience symptoms of COVID long after they have it. So whether or not someone like that could have a disability under the ADA, even though we typically think of things like the flu being not a disability under the ADA as a new complicated question that we'll touch on later today too. The other definition I wanted to go over here is qualified. So qualified means that the employee can perform the essential functions of a job with or without a reasonable accommodation. And essential functions are defined typically by the employer, but there's a basic job duties that an employee must be able to perform. And courts do give deference to employers to define those essential functions. And in terms of reasonable accommodations, accommodations can be any sort of modification or adjustment to an employee's work that helps them perform those essential functions. And it has to be reasonable, which courts typically see as, feasible or plausible. And in the context of job performance, they have to enable the individual to perform the essential functions of the job. So speaking more about reasonable accommodations, employers have to provide reasonable accommodations to the known physical or mental limitations of a qualified individual with a disability, unless to do so would be an undue hardship on the operation of the business. An undue hardship has to be pretty significant. It's a significant difficulty or expense, and it focuses on the specific resources or circumstances of the particular employer. So what may be an undue hardship to one employer, let's say a small employer with 10 employees, may be different than a huge tech company with very different financial resources. So there's no kind of bright line rule in what makes an undue hardship. So just be aware that it has to be a very case-by-case analysis when you're going through that. So a reasonable accommodation can include, as we're going to talk today, it can include leave, and it can also include a reduced work schedule. And requests for leave might first and foremost fall under an existing policy that you have. And so the ADA requires that individuals with disabilities have access to those policies on equal terms. So, for example, if you have a PTO policy where employees can just have 3 days off every year, no questions asked, and you have an employee that comes to you and says, I want to take these 3 days off because I'm experiencing depression and I need some mental health time to recover. You can't then ask that employee to provide you with documentation to verify that depression, because you need to treat them exactly as you would someone coming to you and saying, I'm going on vacation. But what we're going to be focusing on mainly today is leave in and of itself as a reasonable accommodation, even if you don't have a policy that covers it, even if the employee doesn't qualify under your existing policy, or even if they qualify for something like, let's say, FMLA, but they've already exhausted all that leave. The ADA might step in there and have some additional obligations in terms of providing employees with leave for disabilities. So requests for reasonable accommodation, like requests for FMLA, an employee doesn't have to say, any magic words. It doesn't have to be, I need a reasonable accommodation, or under the ADA, I need to make a request for something. It can be as simple as, I'm having trouble getting to work on time because of my medical treatment. Or if you have an employee who recently needs to use a wheelchair and they try to pull up to their desk and they realize it's not, it's too low and their wheelchair can't fit under it, and they tell you that, that in and of itself can be a request for reasonable accommodation. So after the request, that's when you start the interactive process where you come to figure out what best reasonable accommodations you can provide. And note that it doesn't have to be exactly what the employee requests. It just has to be a reasonable accommodation that allows the employee to perform the essential functions of their job. And also note that a reasonable accommodation is not one that eliminates one of the essential functions of the job, which we'll talk about later in terms of, is physical presence at the work site an essential function of the job? So we'll talk more about that, but just want to put that in your mind for now. And then when can you request documentation under the ADA? You can request documentation to verify disability and to figure out what reasonable accommodations could potentially work when the disability or the need for the accommodation aren't obvious. So it's typically, if we can compare it to the example earlier where the employee is in a wheelchair and the wheelchair doesn't fit under the desk, that's pretty obvious, right? But if an employee has depression and they say they need time off, that might not be so obvious that they need that accommodation or what the disability is there. So now I'm going to bring it to Elizabeth to kind of start talking about how we go about analyzing these problems.
So we're going to go through some scenarios and talk about how it is that you should analyze a request for a request for leave when it comes in. And there are really 3 questions, and we've not necessarily put them in the order that you will follow every time on this list, but you need to ask yourself, is the employee entitled to FMLA leave? Are they an eligible employee? Is this a qualifying reason? You need to ask yourself, is this an ADA accommodation request? And if so, what do I need to do differently to assess whether the employee is disabled as a threshold question? And if they are, determine the reasonable accommodation I'll provide. Under the ADA, leave is the accommodation of last resort. And so you need to go through and look first to see if there are accommodations that can be made in the workplace or to permit the employee to continue to work. And then the final thing you need to do is determine whether or not the employee is entitled to paid time off under either your existing policies or under one of the state laws. So let's start with a scenario. You've got an employee who, actually, Amy, is this one yours or is this one mine? I can't remember. Is this one
that one's yours.
Okay, so you have an employee who requests 3 months off because your employee is going to have knee replacement surgery. So initially, you're going to say, are you entitled to any paid sick leave under state law? And you're going to grant that time. But the next question you need to ask is whether or not that 3 months ought to be covered by FMLA leave. Now remember, FMLA leave is only a 12-week allotment, which is approximately 3 months, but it's a little bit shy. And so if your FMLA policy, if you are a covered employer under FMLA, if the employee is an eligible employee, they're probably going to have a qualifying reason for the knee replacement surgery. But you're going to need to determine when their FMLA expires and whether it runs concurrently with their paid time off or whether their paid time off comes first. And that is a matter of your policy. Under the FMLA, you are permitted to have paid sick leave run concurrently with FMLA leave, but you do have to tell employees that will happen. If your FMLA leave is going to expire before the end of that 3-month period, then you may need to engage in the ADA analysis to determine whether the employee is disabled. And if the employee is disabled, whether an additional week of leave is a reasonable accommodation. So you would look at things like, can the employee work from home during that week? Or is there a reason that the employee can't? The employee is going to be spending so many hours in physical therapy and is going to be exhausted and unable to do any work that week, is a different scenario than my employee can't walk into the office for another week. So you would look at things like remote work, especially after the last year with so many people working remotely. You're going to need to take that into account, particularly for office jobs and for jobs that can be done virtually. Even if the employee in this scenario takes the paid sick leave before taking FMLA leave and therefore has adequate time to cover the full 3 months. Under this scenario, when the employee is ready to return to work, the doctor says that the employee cannot return to work full time for the first month. The employee is going to need to work half time. It's not an unusual scenario when you have an employee returning to work. You're going to need to analyze that under the ADA. Is the employee disabled from working full time. And so you'll need to engage in the interactive process. You'll need to know things like, is the employee unable to work in person? What is it about working in person or working at all that this employee cannot do? The employee's too fatigued, they need to sleep half the time. Okay, maybe leave's an appropriate accommodation. The employee needs to be able to go to a lot of appointments. Again, leave might be a reasonable accommodation. The employee is uncertain about the ability to walk into the workplace and can do their work remotely. Perhaps leave is not an appropriate accommodation. So in our second scenario, which Amy's going to walk you through, we have an employee who has a cough and a sore throat and calls in and says, I'm going to miss a few days of work. I'm really sick. And 2 days after making that call is hospitalized with breathing problems. 2 weeks later, the employee is released from the hospital. So it's a long hospitalization. The employee needs a couple more weeks to get up to full strength. How do you analyze it, Amy?
So we want to start here right at the beginning. So an employee comes to you and says, I need to miss work for a few days to recover from ostensibly, flu, sore throat, and a fever. At that point, you're probably thinking, FMLA, does that apply? And likely not, because it's such a short duration. And recall that FMLA applies to serious health conditions that involve inpatient care or continuing treatment by a healthcare provider. But just be careful, because even though it is ostensibly just a flu, it could become a serious health condition, as we'll see kind of in this scenario itself. If the employee is incapacitated for more than 3 full consecutive days, and either they consult with a doctor 2 or more times within 30 days, or they consult with a doctor once and then receive a regimen of continuing treatment, which could be, prescription medication. So just be careful, even if it seems like this isn't serious, it could be a serious health condition under FMLA. But assuming a FMLA doesn't apply here, the next most logical place to go would be your state, if it has paid sick leave, as we just went through with Colorado or Arizona. So here, either one would apply, and they could use that there. But as Elizabeth pointed out, if they do have, if FMLA does apply, make sure they run concurrently if you have that in your policy and the employee is aware of that, and know that those further protections under FMLA are going to apply to that leave too. So when they return, you're going to have to provide them with that job protection under FMLA, even though they're taking paid leave under the state paid leave statute. So it can get a little complicated. And to further complicate things, in this scenario, 2 days later, this employee is hospitalized and they are having breathing problems. So we want to return to FMLA here and analyze, is this a serious health condition now because it has changed in the way that it is presenting, and the employee is hospitalized? So yes, likely this would be covered as a serious health condition under FMLA, and you may start their FMLA then, if you have not already. But let's see, for example, this employee doesn't qualify for FMLA because they haven't worked the requisite amount of time. Don't forget about the ADA, and maybe this is a disability, like we were talking about with COVID. This employee could have COVID. We don't know in this scenario what the underlying impairment is, but certainly not being able to breathe would be an interference with a major life activity. So they could be entitled to leave under that, even if they're not entitled to leave under FMLA. And then, assuming they are entitled to leave under one or the other, when they are released to come back to work, make sure you look and see if they have any work restrictions, because then that might be, let's say they were off on FMLA leave and they come back and they're released to return to work, but they're going to need, breaks every hour just to recuperate and sit down if they have a position where they're standing a lot and talking to people. So don't forget about the ADA there too, because it could come up. So a next scenario here that Elizabeth will go through with you. The employee is pregnant and experiencing extreme fatigue. The employee requests permission to work half-time during her first trimester.
So under Colorado law, companies are required to provide accommodations to pregnant women that they would provide to non-pregnant people. And so in Colorado, the answer is pretty clear that this employee is going to be entitled to time away from work. The employee may be entitled to use paid sick leave if she has any accrued. It's probably not a disability. And whether or not it's a serious health condition under FMLA is going to depend a lot on what the doctor says. So you would probably want to let her know that FMLA exists. My guess is in this scenario, you're going to find that a savvy employee will not apply for FMLA leave because she wants to take 3 months of FMLA leave when the baby comes. Then I'm going to also talk with you quickly about scenarios 4 and 5, which are almost identical scenarios. So in scenario 4, we have an employee who's immunocompromised and doesn't want to come to work in person during flu season. The employee is a bookkeeper. So you get this accommodation request, I'd like to work remotely. With a bookkeeper, it may be possible for your employee to work remotely, and you may go through and figure out that the employee is disabled, and therefore you're going to provide them with this reasonable accommodation of working remotely. Some bookkeepers may need to have some time when they perform work in the office. So you might come up with a hybrid of you wear protective equipment some of the time and work remotely the remainder of the time. But in scenario 5, what we have is an employee whose job has to be done in person. We have an ICU nurse. And in that situation, you're going to be looking at the ability to protect the employee through personal protective equipment. If that is not satisfactory for some reason, if the employee is just so sensitive that PHE is not going to be a good option, then what you have to do is you have to get to that accommodation of last resort and consider whether or not the nurse should be given leave as an accommodation. My recommendation to you is that if you get to that point, you also try to put the nurse on FMLA leave so that the FMLA leave is running concurrently and you don't end up saying, well, you've exhausted your ADA leave. In Colorado, ADA leaves of more than 6 months are generally considered unreasonable. You don't want to get into a situation where you have to provide this nurse with 9 months of leave. And at the same time, you're going to look at running their paid time off, their paid sick leave concurrently if your policy permits it. We have one last scenario, which is, whoops, I think I just skipped it. Sorry. It's what happens if a child, if an employee's child is undergoing surgery for a broken arm. And I think we can do that very quickly again. You're going to need to consider whether they're entitled to paid sick leave under your policies and under state law. They may be entitled to FMLA leave because of the serious health condition of the family member. They will not be entitled to any accommodation under the ADA because we do not accommodate family members. And then we're going to talk briefly and kind of go through these quickly because they are somewhat less pressing. Amy's going to talk very quickly about the family insurance program because we only have a couple minutes before our time is up with you today.
So the family insurance program is somewhat similar to FMLA, but it's funded by both employees and employers in Colorado, and it's set to take effect. So take effect meaning that employees can use the benefits of this program in 2024. Wage deductions are supposed to start in 2023 in Colorado, and it essentially gives employees up to 12 weeks off, plus an additional 4 weeks for pregnancy or childbirth complications. And like the FMLA, intermittent leave is available under this program as well. But unlike the FMLA, it's going to provide pay. So it's going to be 65 to 90% weekly wage replacement based on the average weekly wage formula for employees in Colorado. And it's capped at $1,100 per week. And then the premiums, which are set to be 0.45% of the employee's wages for the employee contribution and the employer contribution are split. So it's 0.90 for when you take both into consideration, unless you're an employer with less than 9 employees, then you don't have to contribute the employer portion. And then there's reemployment rights after 180 days of employment. And we kind of went through that quickly because there's a lot that we still don't know yet, but we expect things to come out about. So keep in mind that this is happening. Don't panic about it yet. Just look for updates on this, which will be forthcoming in the next couple of years.
And then the last thing we want to talk with you about before we get to some of your questions is some developments in USERRA. USERRA is the Uniformed Service Employees Reemployment Rights Act. Sorry, we just call it USERRA so often. USERRA is one of the major parts of USERRA is that it allows employees to take job protected leave while they're engaged in active duty military service or training. So typically, for years, what we were seeing was active duty deployments, but as deployments have gone down, what we're seeing more of is people who are in the National Guard or in the reserves taking weekends and a couple weeks a year for training. There was a recent decision out of the 7th Circuit, and neither Colorado nor Arizona are in the 7th Circuit, but it's still a noteworthy case. And it was the decision in White v. United Airlines. And the question that was presented in that case was if an employer has policies under which it provides short-term paid leaves, is it required to provide short-term paid leave to an employee who is going to one of these 2-week training programs? And the court answered the question affirmatively. So if you have a policy that you say an employee can take 5 days of bereavement leave, and that leave is paid and it does not impact the employee's PTO bank, or if you have a policy that says an employee can take paid jury duty leave without drawing from their PTO bank or their vacation or their paid sick banks, then you have to extend that same sort of leave to employees who are engaged in active duty military service or who are attending their trainings and fulfilling their obligations as guardsmen or as members of the reserves. Now, like I said, it's an 11th Circuit case. It's just one case. We haven't seen what happens, but there aren't a lot of USERRA cases. And so it's important to be aware of that and to be aware that it may be changing the way that employers need to approach those short-term military leaves. Now, let's get to some of your questions. I think we've had more questions come in than we will be able to answer, but we're going to get started at the top. There were several questions about HFWA. The first is with regard to notice. If an employee no calls, no shows one day and then calls the next day and says, well, I needed yesterday off because of a health condition, can you discipline them? You have to give them their time off, but can you discipline them for not providing you with adequate notice? The answer on that is a little bit uncertain because there's nothing in the law that specifically says you can't discipline an employee for not giving you adequate notice or being a no call, no show. On the other hand, the law does prohibit retaliation against employees who are exercising their rights under HFWA. And because HFWA does not require advance notice before it be taken, and it does not specifically say that you can enforce a no call, no show policy, doing so is a little bit risky. You might prefer to speak with your attorney before making that decision. The second question about HFWA is, now that the public health emergency has not been renewed, does the 80 hours just get taken away? The answer to that is going to depend on how you accrued the public health emergency leave. If you put it in its own bank, then employees may use it for 4 weeks after the conclusion of the public health emergency. And at that point in time, it's not clear if it goes away, but it certainly cannot be used. And the employee is not entitled to pay out of that bank when their employment ends. So, it's kind of a moot point whether it goes away or not, because the employee can't use it and can't monetize it. The next question is, do you have to add time to sick banks to equal 80 hours when the public health emergency is declared? Or can you wait to make that time available to an employee as the need arises? And the answer is that you have to supplement it on the date that the public health emergency is declared. The employee is entitled to continue to accrue standard sick leave under HFWA, even after you've accrued that 80 hours. So you are going to accrue as much as you need, or you're going to do the supplement, however you choose to do that, on the day that the public health emergency is declared. And then you are going to continue to accrue standard paid sick leave at the rate of 1 hour for every 30 hours worked. The next question, I'm not actually sure if it's a HFWA question or if it's an FMLA question, but it says, basically, I'm confused about what happens if an employee is in the middle of the shift and says to the supervisor they want to leave for the day and they're going to leave. Can't the supervisor say, well, our business needs are such that you can't go home early? And the answer is going to be no if it's any of these protected, legally mandated leaves. So if the leave is leave under the ADA, leave under the FMLA, leave under one of the state laws, you can't say, no, you can't take that leave. Now, if the employee has taken all 48 hours of their HFWA leave and has exhausted all of their FMLA leave, then you can say, our business needs are such that you need to be here. Unless they have a disability, in which case you need to engage in the interactive process, and you ought to provide the employee with a temporary accommodation while you're doing that. The next question is for Amy, and the question is, when leave is considered as an accommodation under the ADA, what should you do when the employee doesn't provide you with any end date? So I say I'm going to go out on leave, and I'll be back when I'm back.
Yeah, so that's a tough one. If the need for the leave there isn't obvious, you can go ask the employee for more information from their medical provider in terms of what the expected duration of this leave is. Because courts have routinely found that requests for unlimited leave, kind of what you're describing, is not a reasonable accommodation under the ADA because it essentially eliminates the essential job function of performing the job at all, So it's essential, it's important that you get information about the duration, and you can and are entitled to ask that information about what the expected duration is. And if you continue to not get information about what the expected duration is, that's when you should probably consult legal counsel about the next steps to take in terms of how should we go about terminating this employee if we can't get any information, and what to do next from there. And as kind of we were talking about in today's presentation, maybe there's other leave policies that you haven't considered. You want to make sure everything's exhausted before you go on to say, well, this employee is being unreasonable and they're telling me they can never come back to work. And so we're just going to terminate them. Make sure you really thoroughly look at the situation, even if it's a very unreasonable request like that.
Amy, there's another question for you. This one's about the FAMLI program. The question is, will the FAMLI program be a mandatory contribution for all employees? I
believe so, yes. Again, I think maybe that could change, but from everything I've seen so far, yes, it applies to all employers, all employees.
And FAMLI is kind of an interesting and unusual law because it was passed by voters. So it was not successful working its way through the House. And it has a pretty far lead time. So we're anticipating that there will be regulations and guidance coming out in the next year and a half that will explain whether all employees, for example, if somebody hires a nanny, do they have to contribute to the family? Will that apply? If somebody directly employs a home health aide, will FAMLI apply to those people or will it not? And I think we're waiting to see for sure if there are any limitations. Well, we do have more questions coming in, and I am sorry to say that we are at the end of our time. We appreciate all of you joining us for your lunch break. We hope you enjoyed your food and that our talk did not give you indigestion. And we look forward to speaking with you another time and hopefully interacting with you in person one day.
Thank you all so much. We really appreciate your time today.